But your Lordship is very, very sensitive and cautious and careful to create a new status quo by an interim order. Maintaining a status quo and leading to the creation of a new status quo are two different principles of law looked at and dealt with differently by case law. Here clearly a new status quo was created. The fifth principle is actus curiae. Obviously, actus curiae arise in the event that your Lordship finds that I am partially right or fully right, not otherwise. But if your Lordship finds, then your Lordship reverses the most intertwined situations, because the Lordship never allows the act of court to do any harm. Actus curiae nemine gravabit. The sixth facet is, that if there is a right made out, I'm sorry, my apologies.
No, six.
Seven.
Next. Actually, I dictated these later on, so my numbering is also in A, B, C, D, E, F, G, because the main submissions are below in 1, 2, 3, so I don't have those numbers.
Okay.
But your Lordship is right, I'll say next, your Lordship will have your own numbering.
Yes.
Well, is what your Lordship, I'm sorry, this is not that we are using Latin, your Lordship has warned us in recent judgments against using Latin, but these are basic principles. The other one, is ubi ius, ibi remedium. If your Lordship finds that I have a right, in this case a constitutional right, made out by all this which we have been arguing, then at the end of that right to say that I am remediless. The remedy which is effective and real is only a reversal of the status quo ante, as would stand immediately prior to the consequence of those two orders in June. The consequence being the change of status quo on 4th July? 4th June. 30th June is the swearing. 30th June is the swearing. I'm sorry, not 4th July, 30th June. So it must be a status quo ante. In the event that your Lordship applies the principle, obviously ibi remedium doesn't arise unless there is ibi use. If I don't have the use, I don't have the remedium. But on the assumption that I have, then your Lordship will not be told it's a fait accompli.
So what would then be the consequence, Dr. Singhvi? What does the court then, logically, what would be the directions of the court?
Well, logically, the direction is that that particular act of swearing in is wrong, and your Lordship will have the whole thing done again. Your Lordship could then, to give your Lordship, your Lordship give a substantive answer.
Yes. What will be the substantive directions then?
Yeah.
Now,
I am giving your Lordship a substantive direction. Of course, I will develop the law which has yet to come. In the event that that is correct, and that is the majesty of the law, that is what your Lordship means when your Lordship demolishes 25-floor buildings. And the message goes that your Lordship is ultimately establishing the supremacy of the law. Supremacy of law is by no other means except by result, by actual de facto on the ground result. The rest remains paper and words. It would be a reversal of that oath. I'm being very formal and constitutionally proper. A direction.
Oath is on 3rd.
No, I thought 3rd is 30th. I also thought 3rd, that's why I said 3rd. Apparently it's on 30th.
Because on 29th...
that's right. That's correct. That's correct.
Of course, that's correct. 29th evening.
That's correct. Doesn't matter, 3rd or 30th, but reversal of the day before that. Second, for the purity of the process, your Lordship will, there is still a Deputy Speaker, should decide what he would have decided but for Lordship's injunction. Because your Lordship is now counting the status quo ante on the but for test. But for these two orders, what would have happened? Obviously, only this would have happened. There would have been no swearing in and there would be a decision. Well, it sounds sometimes difficult, but imagine. Yes.
So far,
kindly note.
Dr. Singhvi.
Yes.
When you are on the interim injunction,
Yeah.
not granting interim injunction on 29th and to see that the status quo ante is maintained. It was only with respect to the floor test on 30th.
And he resigned. That's what, and Roshi was asking.
No, 1 minute. You can read the. On 30th, on 29th, he resigned. The order dated 29th, not granting injunction, was very clear that the floor test on so and so will be subject to the floor test on 30th will be subject to the ultimate outcome. Correct? Now, in that case, correct, raise the question of status quo ante.
Yes,
correct.
I'm
on
very grateful.
On the basis of the 29th injunction or not granting injunction.
I'm very grateful for a query. Your Lordship was put it in a different way earlier. I must answer it again. It's very opportune at this moment. There are two answers. One answer I gave 3 minutes ago, Your Lordship's court is a court of substance. Always. Not of form. Let me develop it. I'm answering only my Lord's query. Paramount is substance, the heart of the matter. It is true that on that day, on 29, nobody would know what would politically happen on 30th. And it is true that the technical word used is trust vote. But what was allowed to go on was a test on the floor, which is inevitable if 39 vote against. The one and only foregone conclusion, instead of suffering the humiliation of a vote, is to give up in advance. I mean, we are in a real world. There is no arithmetic, no science, no physics, which can change the result on 30th. If these people who comprise this, so the floor, I argued the matter on 29th and the earlier dates. One of the main arguments was that the moment your Lordship permits these people to vote, we were seeking an injunction. Where, how can there be a trust vote with a tainted, how can you have a swimming pool with some part of it tainted with poison?
No, therefore your submission seems to be
that was not accepted.
That not granting the injunction,
yes,
correct, would in fact had facilitated those 39.
No, it was an additional argument, Balas. I'm very grateful. One argument was that this trust vote is completely unreal and futile because you have not excluded the tainted fruit.
On the other hand,
the other argument was, Balas, that if your Lordship has stayed that, stay this also. That was a more important argument.
The flip side would have been that
stay both.
Dr. Singhvi, if you had faced the trust vote
yes,
on the 30th,
yes,
these are open. This is an open vote.
Yes,
right? Because you have to, because that's the whole principle of the whip. If you had faced the trust vote and lost, then it would have been clear as to whether these 39 people made a difference, how they voted, and whether that made a difference to the ultimate trust vote.
So we did not do it. It's a given fact. I can't change it. Right, Balas?
Right.
I'm answering. Balas, let me answer this also.
And the voting pattern would then determine as to whether these 39 who are otherwise facing disqualification motions,
yes,
whether they affected the trust vote or otherwise.
But I appreciate. No.
If you had lost the trust vote only because of these 39,
yeah,
then you absolutely a plausible point that, look, these disqualifications, if they get disqualified, then I win the trust vote. Isn't it?
Let me. So the first part is the conceptual.
I mean, the area is not free from doubt. The reason we are putting it to you is because there is a constitutional question in our mind. That's the.
I hear your Lordship loud and clear.
Yes.
Let me, because certain given facts for us, we can't argue about. The fact of the matter is, nothing happened on 30th. The man did not, go to the trust vote. No doubt about it. Now, the first conceptual answer is, we are now, on what I have been saying and Mr. Sibal has been saying earlier, were legal errors. Whether they were or not, your Lordship will decide on 22nd, 23rd orders. But the argument regarding 29th order was that either you should not have stayed that, but if you have stayed that, stay both. You can't stay that and allow this vote to go on.
Right.
That's the first point to be remembered.
If you have stayed the disqualification, then stay the trust vote also.
It's very unfair and uneven and non-level. Well, if your Lordship is hearing the matter next week, I believe it was on a Monday next, it was listed. Then both could have been held afterwards. The Lordship, as well as in the Karnataka late night matter we did, your Lordship said, not today, next morning, it will happen at so and so time. The reverse is also true. Don't have it there, have it after 4 days.
So your argument To therefore
All this
restate
was obviated.
to restate your argument, what you are really arguing is this, that once you stayed effectively the
Exactly.
speaker from deciding the disqualification petition,
Exactly.
then you should have stayed the trust vote also, because one was linked to the other at the least.
The word linked, inextricably intertwined, absolutely. And that is the answer, the first answer on the conceptual query raised by my Lord Justice Shah.
No doubt
It is
about
true. Technically, one is a trust vote, one is a floor test, one is nobody comes.
But you're right. I mean, because
Substance
at
is
the
what?
trust vote, those people were going to vote.
So that's the first.
That-
Now, second, no, I will go further. Since your Lordship has put a different question.
But still, Dr. Singhvi, the problem still in your path. I mean, the problem still arises.
It would have been
that,
shown on that.
the
definitely.
consequence of these 39 would have really.
No. So let me show.
Would be at the trust
Therefore,
vote.
therefore. Now that will
be
not affect this question. Let me be conceptually clever.
Yeah.
My Lord's query is right, but that will not affect the question I'm arguing now. That will affect, as and when your Lordship takes up the disqualification and says that we find that no disqualification occurs because we don't have sufficient proof to disqualify. That's all that will mean, Maharaj. It will only mean that I have insufficient evidence. And I'll tell Lordship why Lordship.
Nabam says, applying Nabam here, the speaker could not have decided. I mean, I'm not putting that against you, but I'm just trying to analyze.
As the principle today stands.
As the principle today stands.
Correct.
Nabam says that where a motion for the removal of the speaker is pending, he cannot decide the issue of disqualification. You say refer Nabam to a larger bench. But suppose you take this, that well, these 39, that Nabam therefore should not be construed to prevent the speaker from deciding disqualification.
Yes.
And these 39 were therefore liable to be excluded because the speaker would have been justified in hearing the disqualification, notwithstanding the pendency of the motion to remove him, that the speaker would have disqualified these 39 because, as Mr. Sibal said, it's a per se disqualification. It's a clear split.